Relatively briefly, I'm going to comment on a couple of the laws that apply to public employers in New York State or may apply to them. Most of you are in private business and these would not pertain, but just to give you an idea of what some of the statutory alternatives to at-will employment look like. And for those of you who are public employers, I want to make a couple of notes. First, many public employees are subject to the civil service law and Section 75 of the New York State Civil Service Law. This is the default provision for many government employees that says that they can only be terminated for incompetence or misconduct if the employer follows certain procedures, which includes written charges of the basis for the employer feeling that the employee has been incompetent or engaged in misconduct. At the employee's request, there could then be a hearing over the charges with a final determination, which currently is made by the employer, with the potential then for appeals into the court by an employee who doesn't agree with the employer decision. One reason I brought this up now as well is for those of you who are in the public sector and you are subject to Section 75 for some of your employees, the New York State Legislature has passed amendment to Section 75, which will make this a significantly more burdensome process for employers, including giving the authority to make the final decision to a hearing officer that will now have to be mutually selected between the employer and the employee or union, if applicable. The governor has not yet received or signed that legislation, but there's reason to suspect that she will. So if you have Section 75 eligible employees now, make sure you are aware of that legislation. In fact, if you are a school district, you're already familiar with what Section 75 is about to be amended to require. This is generally applicable to teachers and administrators who are certified by the State Department of Education. So again, it doesn't apply to most of you, but for those that it does apply, or if you're wondering about the teacher protections, you've heard of their tenure rights. Once a teacher or administrator has tenure in a school district, they can only be removed for just cause. This law requires that charges be filed. The school board determine there's probable cause to believe that these charges are valid, and then ultimately a hearing before a mutually selected hearing officer who issues the decision that is binding, subject to appeal again into the court. This has for many years been more restrictive than what's available to most non-teachers in the government service in New York, but with the amendment to Section 75, the two procedures will look much more alike. Now, again, one of the reasons I'm pointing out these statutory protections is to note that if we were to somehow in New York City or throughout the state lose the at-will employment regime, then the legislation would impose some form of just cause requirement. In other words, employers would have to be able to prove that they had just cause, however that's defined to mean. And then there may or may not be specific hearing provisions that are applicable, or whether there's a hearing before going into court